President Trump has illegally taken aim at several major law firms for, among other things, First Amendment protected activity. He has issued illegal executive orders and weaponized the Equal Employment Opportunity Commission against many of the biggest law firms in the country. So LegalEagle, along with my law firm, Eagle Team, has taken a stand against this fascist behavior. Eagle Team, along with 500 other law firms, has signed on to a brief in support of law firms like Perkins Coie, who are fighting back. Because this isn't just about one law firm, it's about the rule of law. It's about the Constitution. It's about standing up when government power crosses the line from law enforcement to political retribution. Now, other firms are taking another tack. They are falling over themselves to settle and pledge hundreds of millions of dollars of free legal advice in support of Trump-approved causes. They think that they can buy their way out of this. They think that they can curry favor with an increasingly fascist regime. Well, they are incredibly wrong. You cannot stand up to a bully by giving in. Bullies are like mice with cookies. They always want more. And the law firms that capitulated are finding out the hard way. But that's why some great lawyers and great law firms are standing up and fighting back. Some really talented lawyers at Munger Tolles and Eimer Stahl took the lead in writing this particular brief, which was filed in the Perkins Coie lawsuit, and a version of which will be filed in future cases where law firms fight back against the illegal executive orders. And frankly, I can't say it better than what's in the brief. Here's what we wrote. This amicus brief is filed on behalf of many of this nation's leading law firms. Although we do not take this step lightly, our abiding commitment to preserving the integrity of the American legal system leaves us no choice but to join together to oppose the March 6, 2025 executive order entitled Addressing Risks from Perkins Coie LLP that is at issue in this litigation. The executive order, which is now subject to a temporary restraining order, should be permanently enjoined as a violation of the core First, Fifth, and Sixth Amendment guarantees, as well as bedrock separation of powers principles. But something even more fundamental is at stake. In recent weeks, the president has issued not one, but 5 executive orders imposing punitive sanctions on leading law firms in undisguised retaliation for representations that the firm or its former partners have undertaken, and more may be in the offing. Those orders pose a grave threat to our system of constitutional governance and to the rule of law itself. The judiciary should act with resolve now to ensure that this abuse of executive power ceases. The executive order at issue in this case, and the others like it, take direct aim at several of the nation's leading law firms and seek to cow every other firm, large and small, into submission. On the basis of almost decade-old allegations, the executive order subjects an entire firm, as well as its clients and personnel, to draconian punishment, including the revocation of its attorney's security clearances, the potential loss of clients that contract with the United States, and denial of access to federal buildings and facilities. Such disabilities would threaten the survival of any law firm. The looming threat posed by the executive order at issue in this case, and the others like it, is not lost on anyone practicing law in this country today. Any controversial representation challenging actions of the current administration, or even causes it disfavors, now brings with it the risk of devastating retaliation. Whatever short-term advantage an administration may gain from exercising power in this way, the rule of law cannot long endure in the climate of fear that such actions create. Our adversarial system depends on zealous advocates litigating each side of a case with equal vigor. That is how impartial judges arrive at just, informed decisions that vindicate the rule of law. In the same vein, it is a deeply held principle of the legal profession that anyone, no matter their actions or benefits, is entitled to zealous advocacy on their behalf. The principle is so deeply ingrained that lawyers, going back to John Adams' defense of 8 British soldiers who perpetrated the Boston Massacre of 1770, considered it a core part of their professional obligation to take on representation of clients with whom they disagree, even vehemently. Indeed, the courage of attorneys who take on unpopular clients has long made lawyerdom proud. The work done by amici and other firms like them is indispensable to the success of our system. Many advocate for the interests of the nation's leading businesses and financial institutions, which depend on the stability of the rule of law in order to thrive economically. Others advocate for the interests of small businesses, nonprofit organizations, consumers, workers, and other individuals, and likewise depend on the impartial administration of justice to advance their clients' objectives. Individuals at these firms hold a wide range of political, social, and economic views, even with respect to the representations attacked in the executive orders. But despite those differences, amici are united in their support of the integrity of the adversarial system and the rule of law. The role of amici in firms like them is particularly important when a law firm represents a client challenging the actions of a president or his administration, Republican or Democrat. Checking federal government overreach, whether it be infringements on religious liberty, assaults on the freedom of the press, or burdensome regulation, is a vital part of what amici and others like them are called to do. By definition, such litigation brings lawyers into conflict with the politics and objectives of the executive branch. Since this court entered its temporary restraining order, the administration has redoubled its threats of retaliation against the legal profession. In that regard, the express targeting of law firm pro bono efforts in the 3 most recent executive orders which attack those firms' pro bono representations as activities that make our communities less safe, increase burdens on local businesses, limit constitutional freedoms, and degrade the quality of American elections, is cause for particularly acute concern. For our system of justice to operate, members of the bar must be free to advocate zealously for all their clients, large and small, rich and poor, without fear of retribution. They must be free, in the words of Chief Justice Marshall, to defend the right of every individual to claim the protection of the laws. Without such zealous advocacy, there is no prospect of equal justice under law. History offers indelible reminders of the perils associated with government intrusion into the autonomy of the legal system, and with political retribution aimed at lawyers thought to stand in the way of a regime's particular objectives. In too many countries and instances to name, regimes have disbarred, prosecuted, and jailed lawyers who dared to represent opposition figures or challenge government actions, with predictable results for the rule of law and the integrity of the legal profession. Fortunately, such abuses have been rare in our country's history. Over the past 2 decades alone, elite law firms have represented clients seeking to invalidate major presidential initiatives, from the Military Commissions Act of 2006 to the Affordable Care Act and the Dodd-Frank Act. Until now, it would have been inconceivable that a law firm would risk punitive retribution from the federal government for undertaking representations of this kind. And when state or local governments have attempted to wield the threat of official retribution to deter entities from advocating for what they believe, the Supreme Court has condemned such actions in clear and decisive terms. But that proud tradition is in jeopardy. Unless the judiciary acts decisively now, what was once beyond the pale will in short order become a stark reality. Corporations and individuals alike will risk losing their right to be represented by the law firms of their choice, and a profound chill will be cast over the First Amendment right to petition the courts for redress. Like every lawyer, the members of the amicus law firms have sworn an oath to uphold the Constitution and to discharge the obligations of the profession to the best of our ability. That oath obligates us, no matter our political views, to be faithful custodians of our nation's commitment to the rule of law, a commitment that has made it possible for this nation's corporations to lead the world in innovation and productivity, for our scientists, scholars, and creative artists to contribute so much to human progress, and for all of us to know that we can turn to the courts to vindicate our fundamental civil rights. We therefore feel a special responsibility to stand up now to the unprecedented threat posed by the executive order at issue in this case and the others like it. Now, we're under no illusion that this is going to change the world. This is an amicus brief, a friend of the court brief, that the court may or may not take into consideration. But I signed it on behalf of Eagle Team, along with 500 other law firms. It's something, and it's a start. It's a big sign that says that if you're going to come for one of us, you're going to have to deal with all of us. Now, personally, I think it takes guts to go to court against the federal government when the federal government is taking direct aim at the law firms and lawyers themselves. These firms are risking their reputations, their revenue, their security clearances, and their client base. But they're standing up for the Constitution and for the independence of the legal profession. This is bigger than any particular contract or client. It's about whether the White House can wield the power of the executive pen to crush opposition. Today, it's these law firms. Tomorrow, it could be journalists or whistleblowers or any American. By pushing back, these firms are not just protecting their own rights, they're trying to protect yours. Now, I would like to have seen even more big firms sign this brief, but c'est la vie. Eagle Team is the biggest law firm by number of YouTube subscribers, and in the end, isn't that the most important law firm metric? But things are serious. In Henry VI, when Dick the Butcher says, "The first thing we do, let's kill all the lawyers," that's not a joke, but part of a plan to win a coup d'etat. Law firms are sometimes the first line of defense, and sometimes they're the only line of defense. In authoritarian regimes around the world, one of the first steps in consolidating power is often to undermine the legal representation for opponents. When lawyers fear representing government critics, the government can operate with impunity, which is one reason why I find the capitulation of firms so distasteful and cowardly. Firms like Paul Weiss, Skadden Arps, Milbank, Wilkie Farr, Caldwater Wickersham and Taft, Kirkland and Ellis, Allen and Overy, Simpson Thacher and Latham Watkins. These are huge firms that think they can buy off the president. And unfortunately, they might be right. So if you're in a position to hire a law firm, I know that there are some GCs out there that watch this channel, perhaps consider the firms that are willing to stand up and fight an increasingly fascist regime. Because if a firm isn't willing to fight for themselves, are they really willing to fight for you? Now, I signed this amicus brief supporting Perkins Coie because I believe in the fundamental principles of our legal system. I support the firms fighting these executive orders because they're defending something bigger than themselves. They are defending the rule of law itself. This isn't about politics. It's about preserving a legal system where everyone has access to representation, where lawyers can fulfill their ethical obligations without fear of government retaliation, and where the executive branch doesn't get to choose who can challenge its actions in court. That's what's at stake in these cases. That's why I signed this amicus brief. And that's why all Americans, regardless of political affiliation, should care about the outcome.